Hello, this is Matt on the Moon Lambeau channel. Did the SEC really just give up trying to prove that XRP is a security? Well, there's a reason that seems like just about everybody in the XRP community is talking about this topic, including myself, and there's been, for good reason, a lot of confusion on it, including with myself. I had some questions to ask. And here's why. You may have caught attorney Jeremy Hogan's most recent YouTube video he put out on his very popular YouTube channel, Legal Briefs, and he was running through the motions for summary judgment that were filed, I guess it's been 6 days at this point. In the SEC's motion for summary judgment, they made no argument that XRP actually is a security. They just noted that the scheme and everything having to do with Ripple's sales of XRP and all that, you know, the whole rigmarole. They're claiming that that represents an investment contract and then some, and there are some additional specifics. But still, Attorney Hogan is pointing out that the SEC never claimed that that XRP is a security. So did they really just give up? Why don't cryptocurrency exchanges then just relist it? Because so then you take that point of view and then compare that to what Attorney Deaton has been saying. Because Attorney Deaton has been arguing for the longest time that the SEC, although they'll say on the face of this topic that, yeah, we're not arguing XRP is a security, but then if you look at the language that they actually use in the next breath, they are arguing that XRP is a security. So then I was sitting there, how do we reconcile these two different viewpoints? Do I even fully understand this? Is just one of them right? Is one of them wrong? Well, I'll tell you this at the outset. It's a little bit more complex than that. And they both have incredible points. And I brought this up on Twitter earlier today, and both of them, as well as Attorney Bill, who I'm sure many of you are familiar with, all of them took the time to chime in and share their perspectives, and I was endlessly grateful, and a ton of people were checking out that thread, and I know the entire XRP community is very appreciative of that, you know, spending their valuable time to educate us all and share their perspective. And it really did help, because I've been wondering for a number of days, like, how do you reconcile these two viewpoints? And it's actually pretty easily reconcilable, but I did need clarity from both of them to understand it. And that's what I'm going to drop on you in this latest Moon Lambeau Hot Jam. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so what kicked this all off, in terms of the origins of the threads, which I'm on Twitter, which I'm going to be highlighting here, was this tweet from Ben Armstrong, who of course runs the BitBoy Crypto YouTube channel. And this morning he tweeted out the following: XRP is pumping for multiple reasons, but if I were to pinpoint one, the SEC basically gave up this week trying to prove XRP is a security. People in the Ripple community can be pretty confident now the worst case scenario is a fine. Hashtag XRP Army. And so that's certainly not the wackiest thing out there. In fact, it's reasonable to especially based on what has been articulated to this point, and after listening to Attorney Jeremy Hogan, to think, oh wow, it sounds like, you know, XRP, they're not even, and it's true. Like what he's saying here is true. The SEC in the motion for summary judgment, they're not saying that XRP itself is a security. Is it really the case though that we're out of the woods? Well, ask a different lawyer, get a different opinion, sort of. And I'll explain. Again, there's a lot of nuance to this, so you're gonna have to hang with me on this and pay attention here. Well, Attorney Bill within the XRP community here retweeted that from Ben Armstrong and said, I don't think the SEC has given up trying to show XRP is a security just yet. And this is where I jumped in, because I wanted clarity, because it's been like bothering me. It's been in the back of my mind for like a few days now. I'm like, okay, how do we reconcile Attorney Deaton's opinion with Attorney Hogan's opinion? And so I wrote to Bill there and I said, SEC keeps saying they're not claiming XRP is a security per se, but then goes on to argue that it is. Been doing that since December 22nd, 2020. Is it a surprise they're not saying XRP is a security per se in their motion for summary judgment? And then I tagged Attorney Deaton, Attorney Hogan, and also Attorney Fred Rispoli. And so that's part of what was confusing me too, because I know that Attorney Hogan pointed out in the motion for summary judgment that, and correctly so, that they're not claiming the way that technically they're not claiming that XRP is a security. But I'm like, But that's not new news because they made the same claim. They've been making the same claim since the beginning of the case. So why then is everybody getting all excited because on that point, now that we have the SEC's motion for summary judgment, I'm like, nothing changed, right? Well, I was missing a little piece of information you'll see as we go further, but I want to do this sequentially. So there was good reason for that, actually. But Attorney Deaton responded, and he wrote to me and he said the following. Matt, you and Bill are correct. I never expected them to argue in the summary judgment that XRP itself is a security because they admit they can't. But they still make a de facto argument. For example, they claim the XRP escrow represents the common enterprise. Yeah, and so upon reading that, I was like, that's what I was thinking too, because my understanding was that they were going to keep arguing in line with what they've been arguing, which is they'll keep saying XRP itself is not a security when asked, but then in the next breath they're going to say the totality scheme and however they word it, the whole rigmarole again. They'll still state that effectively they'll make the argument that it is while saying we're not making that argument, but they're making the argument. So they're outright lying when they say that they're not. But anyway. And then so I responded to Attorney Deaton and I said, I see people excited that the SEC doesn't blatantly claim in motion for summary judgment that XRP is a security. Can Judge Torres still find that XRP is a security per se without the SEC making the blatant claim? Or are the accusations the SEC make enough for her potentially? And I don't think he even saw that tweet because he kept talking, but I'll tell you what, if anybody that has kind of like whatever is subjectively to you like a large following on Twitter, I'm telling you, you can go to your notifications and it's hopeless because you're getting constant, like every second of every day, every time I log in, it says 20 plus notifications. Like if I click on this and then come back like a few minutes later, it's going to say 20 plus again. And I'm not complaining, but just some people may wonder, like when you write to somebody that on Twitter that has that many followers, you're not necessarily getting stuff. You're probably not, frankly. It's that there's endless numbers of notifications every time somebody retweets or hits a like or does comment. And so I doubt that John Deaton even saw that particular thing for me, to be honest with you, because he kept talking too. You'll see as we go forward here. So I then tweeted out, wait, actually, I think I can go to the next page here. Wait, sorry, I want to make sure I don't mess this up. Yeah, I don't think I need to read that one. Okay, I thought I had this pulled up. Or I apologize, guys. Let me get there's a lot of threads, and the way this splinters off, it can be complex. Yeah, I think I meant to have this particular one open here. Let me open this in another tab just to make sure. One sec here. So then Attorney Bill said the following. All right. Oh, wait, is that the same thing? No, that's a different one. So this is a separate thread. I apologize. I know it seems like a little scattershot here. It's just because, again, the way these things splinter off, like you can have it's not like perfectly sequential. If you can have a thread going down and then somebody replies to something else and it starts a new thread within the thread, and it's a mess trying to track this stuff. So anyway, Bill said the following, and this is a brand new thread here on the same topic. He said, any purchase of XRP at any time by anyone, according to the SEC, if you buy an XRP, you invest in a common enterprise with Ripple and with me and with Moon Lambo and with someone who bought XRP in 2016 and sold it in 2018, no matter what you did with it. The SEC's formulation, not mine. And then he shared this, and this is actual SEC text, which reads as follows. This is what's on your screen. It says, first, the undisputed facts show that, as a matter of economic reality, a purchase of XRP is an investment in a common enterprise with other XRP holders and with Ripple. So there you go. So that's why, again, like I said, if you ask the SEC, are you claiming XRP as a security? They say no, but then they make arguments like this that say yes. So, you see how ridiculous it is? And so then Attorney Deaton retweeted that from Attorney Bill, and John Deaton said, exactly the point, Bill. Thank you. I can't tell you how many people would point to the line in the SEC's motion that says, we aren't arguing the token itself. But then, in same paragraph, say anyone who buys XRP enters into a common enterprise with Ripple and everyone else. And so then we get to this part. So I responded to Attorney Bill and I wrote, makes sense. So, and to be clear, that part did make sense. I know that the SEC is saying, no, we're not claiming XRP as a security, but then arguing that it is. I already knew that. So I wrote, makes sense. But I still think I don't understand something sufficiently. Can you help me make sense of this? I don't understand why people got excited by the SEC's motion for summary judgment purely because it doesn't blatantly state XRP equals security. And so again, the reason that I was saying that is because this was a known factor. The SEC has been taking this approach since 2020. So I'm like, why the excitement now? And there was a piece that I was missing, but we're getting to it. I got to do this all in order. Otherwise, it gets really messy. It already splinters off in a messy fashion the way Twitter works. But Attorney Deaton did respond to me and wrote, my guess is that people expected a stronger brief. And so I think he's talking about the SEC brief there. My guess is that people expected a stronger brief. I'm not with everyone who thinks the SEC can't on some level, but the SEC offered no evidence on XRP holders relying on Ripple's promotion or promises, etc. I was expecting their expert to discuss social media and examples, etc. And fair enough, that makes all the sense in the world. Now here's where we really start to get to like the meat of this, like what actually happened here. So like, how is it? How do you reconcile these positions where Jeremy Hogan says the SEC is not arguing that XRP is a security, that there's no claim in the motion for summary judgment, which is, we're at the end of the case here, even though, there's still many, many months before it's technically settled, but in terms of what's being argued, we're at the end of the case. And then how do you reconcile that with John Deaton saying, no, they're arguing that XRP is a security even now. So here's where we get to, like I said, we're starting to get to the answer, but I had to do all the setup. I'm sorry, I know it took a long time, but if I didn't do this, then the answers wouldn't make any sense. There wouldn't be sufficient context and all that. So then I wrote to John Deaton, and this is the one after he was trying to explain why he thought maybe people were excited, after seeing the SEC's motion for summary judgment. And I wrote, in response to that, that part makes total sense. Additionally, it seems like you're saying the SEC is arguing XRP is a security, and Hogan is saying the SEC is not arguing XRP is a security. That's what I'm confused about. I may be misinterpreting what either of you or both of you are saying. And I will say, I was very concerned about this. I didn't want to, it's hard to understand what somebody's getting at when you can't see the emotion behind words, and then you're limited by the number of characters on Twitter. It's not the best medium for sharing ideas, but it's popular. It is what it is. So we use Twitter. But I would never want to put words in either of their mouths or misrepresent them. And of course, if any of the attorneys here are listening to this video, if I get anything wrong, please let me know. I promise I'm operating in good faith, but if I do get anything wrong, let me know, and I will promptly issue a correction in a future Moon Lambo Hot Jam. But I do think I have this right. I have a high level of confidence. Hopefully that's correctly placed. So again, I wrote, I may be misinterpreting what either of you or both of you are saying. And I was concerned that perhaps I was. At a minimum, I thought I was missing information, and that part definitely was true. And then I wrote, I will attempt to summon Jeremy Hogan for clarity. And I tagged him there, and he did respond. And he wrote, with his I love his sense of humor. It's similar to mine in many ways. He wrote, I am responding, oh great Master Matthew. I agree that the complaint alleges enough to make the argument that XRP is per se a security. But the motion for summary judgment only asks for a judgment that the defendants sold XRP in violation of Section 5. I don't see how the judge could rule sua sponte for more relief than is requested in the motion in front of her. There's no request for an injunction or even for a declaratory judgment, which would put it at issue. And so as soon as I read that, I was like, okay, that was a piece of the puzzle. That's an important piece of the puzzle that I was missing there. So although we knew that the SEC had been saying, no, for the longest time, no, XRP is not a security, but arguing that it is. We knew that. But the important piece here, because this is the final document at the end of the case, this is the final opportunity for the SEC to say something different or pull something out their rear sides, which they frequently have done throughout this pretrial phase. But this is basically the final, among the final documents to be issued, right? And they're not arguing in the motion for summary judgment that XRP is a security. And so when it comes to what the judge can do, the judge isn't going to rule that XRP is a security because she wasn't even asked to consider that. Do you see that? Now that's a key piece of information that admittedly I was definitely missing there. That helped quite a bit. So I responded with the following. LOL, thank you. Okay, so you're saying, I think, that the judge cannot rule XRP to be a security since the SEC didn't ask the judge for such a consideration. Is that right? And if so, given that XRP can't be found to be a security, why don't exchanges now relist XRP? And Jeremy Hogan gracefully responded to me, and he wrote, yes, basically. But the law is open to interpretation, and John and Bill seem to think otherwise, which is good. Always room for discussion. I differentiate between the complaint, which is one thing, and the pending motion, which is related but also its own separate thing. Okay, so there, and this next part is where it all clicked for me, and I was like, I got it now. I finally get it. I understand where the confusion came from. I'm not the only one that was confused about it, and now we've gotten to the bottom of it. And there are all sorts of people, as the thread splintered off, tell me, yeah, I've been wondering about that too. Well, we don't have to wonder any longer. So here's where I was spitting back what I believed I heard from him, and I firmly believe this is accurate. Again, if anybody, any of the attorneys out there, if I got this wrong, please tell me, and I will issue a correction, but I feel highly confident this is accurate. And so I summed it up in 2 tweets, which are on your screen right now, which read as follows. Okay, that helps a lot. Thank you so much for taking the time to clarify. John and Bill think there may be a possibility the judge could render a disastrous ruling regarding XRP, even though in the motion for summary judgment, it doesn't ask for XRP to be declared a security, while you don't think the judge could render a disastrous ruling because the SEC didn't ask for it. If I got that part right, then I think I'm finally no longer confused. It's great to get opinions from all the attorneys in the XRP community. Everyone really appreciates it. Yeah, and so in terms of what's likely, I don't pretend to know. I'm not an attorney. I just play one on YouTube. I don't know, man. But that explains the differences in approach, and they're both perfectly reasonable. In fact, John fleshes this out a little bit further, I think in this tab. Yeah, check this out. So there's the tweet, again, going back to, this is the one where Jeremy Hogan was letting me know that, yes, I basically understood. He wrote, yes, basically, but the law is open to interpretation, and John and Bill seem to think otherwise, which is good. Always room for discussion. That tweet. Well, attorney John Deaton responded to that and said the following. So he's expanding upon his ideas at this point. He says, I don't disagree with Jeremy that the summary judgment is more controlling. But in the summary judgment, they still make conclusory statements about XRP. Quote, a purchase of XRP is an investment in a common enterprise with other XRP holders and with Ripple, end quote. So you can see what Attorney Deaton is arguing there. He's saying this is part of what is going to be considered for summary judgment. So there's a little bit of a disagreement between Attorney Deaton and Attorney Hogan. Not a monstrous one, not a huge one, but an important distinction. And now I can see why I was confused, and everybody, well, maybe not everybody, but a lot of other people were confused as well. He's saying this is the motion for summary judgment, and they're making these claims. And so anyway, let John Deaton speak in his own words, though. Then in the next tweet he wrote, and this is a quote from the SEC, I believe. He says, all units of XRP are fungible with each other, and the price of all units of XRP rise or fall equally, end quote. And then John says, also, an exchange isn't going to list XRP because the SEC didn't use words like XRP itself is a security. They claim Ripple is violating the law by selling XRP in 2013 and today. Who has Ripple sold to? Exchanges. Exchanges pair the offer and sale. Ripple is the issuer to the exchange who has an intent to transfer the asset further. So the exchanges are still in play. Now they should relist XRP anyways, but it won't be because of the motion language, in my opinion. Yeah, so it's still a train wreck. So as far as why won't they, well, there you go. You know, just because they didn't say XRP is a security in those words in this motion for summary judgment, it doesn't mean that there's magically clarity. I mean, obviously, the judge needs to settle this, right? And so I think this helps really bring the point home even further. There was an XRP community member who responded to John and wrote, his name's Wilo, I'm sorry if I'm saying that wrong. He said, inadvertently stating it is a security by their definition without flatly stating it is a security per se, correct? Dodging saying it outright, but not closing the door on the argument is how I read it. Yeah, and that's correct. Like, that's how I've been reading it. That's effectively what I think Attorney John Deaton's been saying for the longest time. But John expanded, and he wrote the following in response. This is how to look at it, in my opinion. Assume the judge were to only write, the SEC's motion for summary judgment is granted, and nothing else. I'm not suggesting she will do that, because she won't, but for the sake of discussion, she does. What clarity, if any, do we have? Yeah, exactly. So depending on what the judge writes, if it's not sufficient, I mean, she's going to write something, but even if it's not necessarily sufficient, I'm not saying it wouldn't be sufficient, but if it weren't, what kind of clarity do we necessarily have? See, so you can see where the problem would come in. So as far as Attorney Jeremy Hogan's stating here, yeah, she's not going to rule explicitly that XRP is a security. That's the argument anyway. But do you see how there's this open door here where depending on how Judge Torres writes up her conclusion regarding summary judgment, if assuming that's the route that it goes rather than a jury trial, depending on what she writes, do you see how there's still an open door there potentially? So I get both points. So it sounds like Attorney Jeremy Hogan is correct, and it sounds like Attorney John Deaton is correct. But you see how nuanced that is? And that's the reason that I wanted to highlight that. It's not necessarily that either of them is necessarily wrong. And there's like some overlap in ideas that are actually a bit different. You see what I'm saying? So that's why, again, Attorney Hogan's saying the judge can't rule on something that she wasn't asked to rule on. But John Deaton is saying, again, to be clear here, because the door was left open, there are any number of ways that you can interpret it that could result in an insufficient lack of clarity. So those things are not mutually exclusive. So it's not about right or wrong. I thought it could be potentially at the beginning, but after getting all of the comments from Attorney Deaton and Attorney Hogan, I was like, oh yeah, I don't think anybody's wrong. It just seems to me like there's a lot of nuance to this. And I think now I finally understand what they're saying. I think I got that right. If I didn't, oh my God, F my life. But it was. I really do appreciate though all of the attorneys taking time to share their information with the entire community. So I hope this cleared this up, because again, I know for sure based on interactions on Twitter, I'm not the only one that was wondering about this. But I'll go ahead and wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.